Good afternoon, everyone. I'm Namita Wahi. I'm a senior fellow at the Center for Policy Research and director of the Land Rights Initiative. And on behalf of the Land Rights Initiative and the Center, I am very pleased to welcome all of you to the third talk in the Land Rights Initiative speaker series on legal history. The Legal History Speaker Series at the Land Rights Initiative is one of a series of events that we have launched in order to celebrate Land Rights Initiative's 10th anniversary, which is coming up in November this year. Why we wanted to do a series of talks on legal history is because all of our work, whether it is on land acquisition, land rights of scheduled tribes in the scheduled areas, and of course our work on the Mapping Indian Land Laws project, as well as our work on property rights, health rights, and water rights, has a legal historical approach to studying issues in the present. In fact, as we have seen in the work on the Mapping Indian Land Laws project, the shadow of the colonial period looms large on our present times. In particular, for the Mill project is the first ever interactive exploratory archive of all land laws for the center as well as for 8 states in India, and we have currently about 150 colonial land laws and 350 post-colonial laws that are on the website. And while doing this extensive work, we found that it is not a binary way of thinking about the colonial and the post-colonial, which is helpful in the sense that the colonial is bad and the post-colonial is good. In fact, there is a lot of detail and nuance in terms of understanding what it is that the colonial laws have to say for the present times. In our work also on land rights in the past decade, we have learned that the academic distinction between civil and political rights on the one hand, which includes the right to free speech, and social and economic rights on the other, which includes land rights, water rights, forest rights, disappears. And that in order to advocate for any right, whether it is a land right or a water right, of course also the land, water, forest rights are inextricably intertwined because they are part of one ecosystem. But really, to advocate for any right on the ground, we need the right to free speech. And it is in that context that we have organized this third talk on the evolution of free speech in colonial and post-colonial India. And I'm very happy to introduce to you Dr. Gautam Bhatia, who is a constitutional lawyer and legal scholar. Gautam wrote this book called Offend, Shock and Disturb Free Speech Under the Constitution about a decade ago. He has written many books since then on the Indian Constitution: The Transformative Constitution, A Radical Biography, Horizontal Rights, An Institutional Approach, and Unsealed Covers, A Decade of the Constitution, the Courts and the State. He's also contributed chapters on Directive Principles to the Oxford Handbook of the Indian Constitution and Religious Speech to the Oxford Handbook of Freedom of Speech. He's the founder and editor of Constitutional Law and Philosophy, a blog that has been covering Indian constitutionalism and the courts for the last 11 years. And Gautam holds degrees, and I'm not going to list all of them because I promise not to embarrass him. But he holds degrees from the National Law School of India, University, Bangalore, which is also my alma mater. So I feel, one of the things, and from the University of Oxford and from Yale University. But I think what makes me really proud, to see his career is the contributions he has made through all of these books, but also through his blog called, he's the editor of Constitutional Law and Philosophy, a blog that has been covering Indian constitutionalism and the courts. And this blog is something that all of us sort of refer to. So I would say that Gautam is a public law lawyer in the true sense because he has taken the law to the public and really made it accessible to everyone. And if this were not enough, he has also participated as a lawyer in the most important constitutional cases of our times, including the Electoral Bonds case, which was decided by the Supreme Court just a few months ago, and the Article 370 case. His books and academic scholarship have been frequently cited by the Supreme Court and the High Courts, even as he practices before both of those courts. And he's served as amicus constitutional for the Supreme Court of Kenya. So his sort of scope and reach extends beyond India. Getting 2 more manuscripts in the next week. So without further ado, Gautam, very warm welcome to CPR and to LRI, and looking forward to what you have to say on the evolution of free speech in India.
Yeah, thanks. Thanks so much for inviting me to do this. So I just thought that what I'll do is I'll do like a whistle stop tour through the history and the evolution of freedom of speech in the colonial period through the Constituent Assembly and then beyond in the course of around half an hour, and then we can enter into the discussion. What we think of as free speech as a right that is enforceable against the state, a right against censorship, a right that enables us to contribute to a broader culture of democracy. You see the first glimpses of that much earlier than you might imagine. You see it in the early 1810s, in this brief period of flowering of liberal thought, headed by people like Raja Ram Mohan Roy, who, in various memoranda and petitions to the then ruling East India Company, makes what we now understand as the democratic argument for free speech, even though, of course, democracy as an idea was still much further in the future in India. And he makes that argument against the closure of critical newspapers, and so on. Of course, the then ruling dispensation pays him no attention. Although, interestingly, and this is something I was quite struck by, his ideas influence people much beyond India. So, in fact, in the constitutional revolutions in Europe, his name is invoked. And when the Constitution of Cadiz is reissued in 1820, it is dedicated to him. So even though his arguments might not find a purchase in India at the time, they are influential in Europe, of all places. Just a interesting aside. So the genealogy of making arguments for free speech, arguments embedded in this idea of how free speech is essential to make rulers accountable, essential to communicate information between the governors and the governed, that begins with Raja Ram Mohan Roy. There is then, of course, a period of silence in a certain sense. And what we next find is almost a call and response relationship that then happens, where the British enact legislation with restrictive provisions, speech restrictive provisions. As the Indian nationalist movement begins to gather steam, speech is used to communicate many different kinds of dissent, political, cultural, and so on. And then you have fresh laws brought in to curtail that. So it's almost a cyclical relationship. A particular idiom is discovered by the nationalist movement. The British come to clamp down on it. Theatre plays a part. You have a new act to regulate theatre. Newspapers begin to expand. You have a press act. Political speech begins to take center stage. You have sedition and so on. So, this becomes almost a cyclical relationship. One of the key features that animates legislation at this time is what is broadly called the rule of colonial difference, which is that the British enact laws in India which would go against the fundamental tenets of English common law. And this is across a range of areas. So, for example, in English common law, you can't have a search without a specific warrant that specifies what will be searched and for what reason. Whereas in the Criminal Procedure Code, now replicated in the new laws, you have warrantless searches. And the justification is that Indians have not yet reached the level of political maturity to be governed by the more liberal legal framework that is used in the colonial metropolis. And that becomes the basis of criminal laws. and specifically the speech restricting provisions in the Penal Code. Now, interestingly, some of the most notorious of these provisions aren't actually part of the original Penal Code. They come in later, which, again goes back to the point of this, there almost being a relationship between what happens politically in India and the legal response. For example, sedition, although it was part of Macaulay's original draft Penal Code in the first half of the 19th century, is not there in the Indian Penal Code of 1860. It comes in a decade and a half or so later as a response to the rise of the Wahhabi movement. So then for the first time you have sedition, which is why it's section 124A of the Indian Penal Code. That A will tell you it's an amendment which comes in later. And sedition uses the phrases, speech or acts or words that bring into disaffection, contempt, or hatred His Majesty's government in India. So it's very clear that it is meant to quell political speech. You also had criminal defamation, which was gradually being abandoned in England at the time, but it is specifically there in the Indian context, again, to quell political speech. In fact, originally, the origins of criminal defamation were defamation against the king. Of course, it occupies a different form later on. So you have criminal defamation. A few years later, in the 1920s, in response to communal tension, of course, part of it sponsored by the British in North India, you have Section 295A, which we commonly understand as the Blasphemy Code, which prohibits the intentional insult to religious belief. The justification of this provision is another important concept, which is this idea that the British had, which existed across the board, that you treat Indians not as individuals, but as members of rigid, defined, and in a certain sense, unchangeable groups. And the task of, and this will come important later on, the task of whoever is governing India is to ensure a certain kind of parity between these groups. And so laws that, for example, criminalize insult to religious beliefs are not enacted because there is something intrinsically valuable about religious belief that you want to protect, but you want to ensure a certain kind of order between different communities. And therefore, you grant the state the power to regulate a certain kind of expression that is being used to foster that kind of disorder. And then you have 153A as well, which again refers to spreading enmity or ill will between different classes and communities. So there is this underlying logic that the British have, which also infects the speech restricting provisions of the Penal Code. Along with that, you have special laws. So a number of different press acts that involve censorship of the press. They involve requiring the press to clear certain kinds of material. They involve confiscation of press material and so on. And often during a time of war, like World War I or World War II, these ramp up in intensity, and then after the wars they come down, and it goes up and down a little bit. And then you have other kinds of regulations. So Dramatic Performances Act regulates theatre, because theatre has been seen by the British to be a way of transporting a certain kind of cultural value that could threaten British rule, and so on. Now, the interesting thing is that in large part, the nationalist movement, its response is shaped by these laws, and therefore civil liberties and specifically free speech becomes a central plank of the nationalist movement. So, of course, Gandhi famously calls sedition as the prince among these oppressive provisions. Indian freedom fighters use sedition trials as political theatre, as a way of putting across their views to the Indian public. Many of the Indian nationalists are imprisoned under sedition laws, Tilak, Gandhi, and so on. In 1936, you have the formation of the Indian Civil Liberties Union, which is modeled on the ACLU, the American Civil Liberties Union, and its head is Nehru. So, in that way, you have, again, free speech and civil liberties being a central plank of the national. In a speech delivered in 1945, Hansa Mehta makes a very strong case for the right to free speech and says only in the case of an emergency, a declared emergency, should you be able to restrict free speech. And of course, Gandhi himself had said that the right to free speech extends to the right even of people to discuss revolution. So only when it rises to violence that you have to have a restriction, and even then it should be the police and not the army which comes in and does what it has to do. So that is in a sense the position in the colonial era. Now in the framing of India's constitution, looking back upon this history, and many of the prominent framers of the constitution were those whose speech had been restricted, censored, stifled in the colonial times. But they do an interesting volte-face, and two clear lines of thought emerge in the assembly, and the debate then focuses on what becomes Article 19(1)(a) of the Constitution, which is the right to free speech. Because when this right is introduced for the first time, it brings along with it a whole raft of restrictions, which of course are still there. And interestingly, one of those is sedition. So actually, the first draft literally says that sedition is a ground to restrict free speech. And of course, there is an outrage and there is uproar in the assembly. And of course, many people say, look, these are the laws that the British used to imprison us, to restrict our speech. What are they doing, in free India? And there you have these two lines of thought. So one line of thought is that, look, we fought for freedom, and that fight included this fight for civil rights, civil liberties. Free speech is fundamental to that fight. This new constitution must be informed by that long history. It must respect the sacrifices made to bring us here, and therefore it must provide an expansive free speech clause and severely limit the grounds on which you can restrict speech. That's a classical argument that's been made. And in a piece on this clause, Nivedita Menon points out that interestingly you have both the right and the left, insofar as these terms mean anything particular, converging on this position, because they were both concerned about being persecuted by the incoming Congress leadership. So on the right you had K.M. Munshi, who made what you think of as impeccably liberal arguments for the right to free speech. On the left, you had the socialist Somnath Lahiri, who said this draft constitution looks like a police constable has framed it. And at one point, he says that, and Patel was a major supporter of these clauses. He said that if Sardar Patel is so popular as he's claiming to be, why does he need the police power to enforce that? Let him, have the free debate and let his ideas be tested. So you had your classical free speech arguments being made, by the Congress's opponents, both on the left and the right. And interestingly, of course, as some of you know, the first two free speech cases after independence involved censoring a magazine on the left and on the right. So the communist magazine Crossroads and the right-wing magazine of the RSS. So it's an interesting tidbit of history over there. But the other point of view was that, look, the problem so far that we've had all these years was not that the state was given this power to censor and to restrict speech. It was just that the power was in the wrong hands. So far you have this alien government, the British. They were misusing and abusing this power. Now we will have an Indian government elected by the Indian people. We of course will not misuse this power. In fact, we need this power to ensure that the gains of independence are not squandered away by allowing for malcontents and various kinds of people to utilize these new liberties to overthrow the state itself. And that was the view expressed by prominent Congress leaders and others who supported them. So the battle over the shape of the free speech clause was a battle over these two broadly contesting streams of thought. The opponents of the Congress had some success in that they managed to get sedition dropped from Article 19, Clause 2. But in other respects, the original constitution had these wide-ranging restrictive clauses, security of the state, defense of India, decency or morality, and so on. So when the constitution came into being, it came into being with the right to freedom of speech, along with all these restrictions, which led scholars like K.G. Kanlabiran many years later to say that in some sense it feels like in the Indian Constitution the restrictions are fundamental and the rights are ancillary, and that's been the common critique so far. But of course, constitutions are not self-interpreting texts, right? So they are terrains of contestation, of debate, and so the battle then moves to how do you interpret these free speech clauses, how do you interpret the restrictions, and so on. And that battle, of course, moves to the court, which has been given the power under the Constitution to interpret, both laws and the constitutional text. So, like I said, initially, the first two cases before the Supreme Court involve the banning of a left-wing magazine and a right-wing magazine, both under state laws, laws passed by the provinces before independence, in the then Madras and then Punjab, and both are challenged before the court, and the Supreme Court strikes down both laws on the basis that the justification given in the laws for banning a newspaper or a magazine is that if, in the opinion of the government, this periodical or text would undermine public order. And the Supreme Court says, look, there is no public order clause in Article 19, Clause 2. There is a security of the state clause, but that is of a threshold that's much higher than public order. So since you, the constitutional framers, have not put in a public order clause, you cannot restrict speech on public order grounds. That's just a straightforward, in fact, conservative textual reading of the Constitution. Not what we think of now as activism, in whatever that might mean, but literally a black letter reading of the constitutional text, which the court then supports by saying that, look, now we are a democracy. Speech is fundamental to a democracy, and therefore our job as the court is to ensure that the restriction clauses on free speech are read in as narrow a way as possible. So we as the court must ensure that we give maximum play to speech and limit the extent to which the state can restrict speech. That is the interpretation given in these two cases, Ramesh Thapar and Brij Bhushan, legendary landmark cases in Indian constitutional history. Now, this leads to a lot of heartburn in the government. They don't like this interpretation, and they immediately move to amend the Constitution. Now, one important thing to remember here is that this is 1950. At this point of time, we don't yet have the first elected parliament. That comes 2 years later. So what we have right now is that the Constituent Assembly was basically performing both functions. In the morning, they were drafting the Constitution, and in the afternoon, they were sitting as the provisional parliament. Now, there is a whole other discussion to be had about how that affected the Constitution, but we won't go into that right now. When the Constitution was enacted, there was still a 2-year gap between that and the first elections. So the assembly then became, in a certain sense, a permanent provisional parliament until the election. So when they wanted to amend the Constitution in response to these two judgments, it's important to note that this amendment came from the assembly itself. The same people who drafted the Constitution then amended it because they didn't like these judicial decisions, which is important to understand, I think. So one common puzzle people have is that how was it that the Supreme Court, after these first two judgments, later on became a completely different court on free speech, which we'll just come into in a moment. One reason, of course, is that different judges, the composition of the court changed and so on. That's one explanation. But I think that another explanation is that the First Amendment, which changed the free speech clause, among many other things, was also a signal by the Constituent Assembly that, look, Supreme Court, you have misunderstood what this Constitution is about. And we are going to correct that misunderstanding now. And henceforth, we need to understand that this is what it's about. Right? So what the First Amendment did was that it substantially expanded 19.2. So it brought in public order as a ground, and other expanded grounds like incitement to an offense and so on, which not only changed the language of the clause, but also, in my view at least, was a rebuke to the court's interpretation that the purpose of 19(1) and 2 was to give the narrowest possible reading to free speech and give the fundamental rights clause a wider reading. There was a different view, which was that, look, in the interests of maintaining what is broadly a well-ordered society, the state has to act upon certain kinds of speech to the extent that free speech serves that goal of maintaining a well-ordered society. The court will intervene, but when it doesn't, then it is legitimate to restrict speech. And this you see in three cases that come up in the years after this amendment. You can call them the IPC trilogy because they refer to challenges to three IPC provisions that, of course, were colonial in origin and were persisting after independence. These three being blasphemy, 295A, which we discussed, sedition, and obscenity, 292 of the IPC. So these are challenged in succession over a period of 5 years, 57 onwards. Right? And they're all upheld by the Supreme Court, which is really a very sharp turn from its previous two judgments of Ramesh Thapar and Brijbhushan. The reason that the Supreme Court gives in these three cases, even though they belong to different domains of law, is broadly this idea of a well-ordered society. Right? So the blasphemy law is upheld not on the basis that there is an inherent or intrinsic value to protecting people's religious convictions, which of course is something that you would find in many theocratic states. The Supreme Court can't invoke that because, of course, this is a secular constitution and is committed to a certain kind of secularism. But what the court says is that if you indulge in intentional insult to religious feeling, there is a possible tendency of such speech leading to public disorder. So interestingly, the blasphemy clause is upheld not on religious grounds, but on public order grounds. And the same argument is used to uphold sedition, despite long history. Basically, that every state has a right to defend itself from being overthrown by its internal opponents, and spreading disaffection, contempt, or hatred of the state has a tendency towards that ultimate overthrow of the state. And that's the basis on which sedition is upheld. Obscenity is upheld also on grounds of order, but the moral order, because the test that the Supreme Court uses to uphold it is something called the Hicklin test, which is a Victorian era test of obscenity. And there the standard is that does a particular text or speech or a speech act have the tendency of corrupting the morals of those into whose hands that might fall. So again, you have this idea of moral corruption or a breach in the moral order, and the state's obligation is to maintain both public order and the moral order. And the court's role is as a partner to the state in ensuring that that is maintained. One interesting bit, and this recently has come up in archival research done by Abhinav Sekhri, is actually that this question, so the obscenity case was a case called Ranjit Udeshi. Udeshi was a bookseller, and the book was Lady Chatterley's Lover, right? The famous book. Interestingly, it turns out that the decision to ban that book went right up to the Prime Minister. So actually, there's a file notation by Nehru saying that, like, what is all this filth? Like, just we have to ban this. So the Prime Minister actually is taking decisions on banning books, which are apparently going to corrupt the moral order. And then the court acts as the partner of the state in that joint, almost like a nation-building project, of ensuring that this new Indian nation is strong both in terms of maintaining public order and as well as maintaining the moral order. Now, I think that sets the tone effectively for the rest of the history of Indian free speech jurisprudence. So you have judgments of the same kind, which uphold the film censorship regime in 1970, K.A. Abbas, a similar kind of idea of films being able to affect the psyche of Indians. You have this judgment on book bans, where you have this very bizarre statement made by Justice Krishna here, who's otherwise very famous, where he says that whoever by books or bombs affects the public tranquility will be subjected to interdict. Now, imagine a Supreme Court judge using books and bombs in the same sentence, and this is supposedly a liberal judge. This is supposedly a legendary Krishna Iyer, who was great on civil liberties. Well, that's sort of the standard you have in the Supreme Court when it comes to, their comfort with what they think of as being subversive speech. It's a very low level of tolerance that they have. And you can trace it back to, I think, basically the First Amendment, the signal it sent to the court about what you're meant to do with free speech, and this trilogy of cases where a certain kind of idea about free speech was set out, which really was this idea that ultimately the extent to which we protect free speech is not because of any inherent value in being able to speak freely, but because it plays a role in a certain kind of democratic discourse, and speech that's outside the pale of that discourse, is something that the state should suppress, and which the court should support the suppression of. We can discuss other judgments. There were some others that came in after that. You have the odd exception, of course, the Shreya Singhal case a few years ago that struck down 66A of the IT Act, which criminalized offensive speech. But even there, the blocking rules, were upheld, and this continues. So you have the Anuradha Bhasin case from 4 years ago, which was about the internet shutdown in Kashmir, which went on for many months. Even after it was lifted, it was first, there was 2G, restored, and so on. So it was basically a blackout which went on for a very long time. This was challenged in the Supreme Court, and the arguments were made that this is disproportionate. Even if your goal, is to ensure that terrorists can't communicate with each other, there are ways to do it. So, for example, you can have a blacklist, or you can have a whitelist. Basically, there are many options that you, the state, have to achieve your security goals that don't involve the complete shutdown of the internet in a whole state. And Supreme Court's answer was that yes, it's bad, but ultimately we will send it to an executive committee to look at, and they will decide when you lift this ban. So quite farcical in that respect. But that is, as I said, I think the important thing is to understand this as being a continuous and uniform and consistent approach of the court towards free speech. That is, I think, has continuities across the board. So the colonial times, and then the Constitutional Assembly, and then the post-colonial times. There is a certain kind of continuity that is there in how you treat free speech, with of course a few dissenting strands that happen at all times, which has always been the case. The dominant perspective is that. So I think that's, in a sense, a short history of free speech, in India. I think it's exactly half an hour, so I will stop at that point, and we can open it up for discussion.
Thank you. Thank you, Gautam, for that very concise, but pretty comprehensive history of the law of free speech in India. And I think I will take the liberty of asking the first question, which is that given your extensive work in comparative constitutional law, not just in Kenya, but I'm sure in other countries as well, my own experience of the United States Constitution, which in the time that I spent as a lawyer there and in my teaching, is that is the one area where the US Constitution is very liberal on free speech. And so I was wondering if you could reflect a little bit on comparative context, both in terms of not just Kenya, but possibly also Uganda and East Africa in general probably have the same codes as us because of the history of colonization. So do they have the same kind of challenges with free speech as we do? And what do you think of other constitutions like the US Constitution?
Well, that's a really interesting question. I'll begin with an example. So at the same time that the Anuradha Bhasin case was going on in the Supreme Court, there was the Yellow Umbrella protest in Hong Kong, which you may remember, and the Hong Kong executive, issued this order in council, where among other things they banned the use of face masks in protests because the Hong Kong people were using face masks to, of course, avoid being identified by security cameras and a standard protester, basic 101 of protests. So they, passed this ordinance that banned face masks and then a bunch of other restrictive law provisions about assemblies and protests. And remember that this was a Hong Kong that was under serious pressure by the Chinese state, right? And the Hong Kong Court of First Instance actually struck down a good part of this law and deployed the same argument that we were using in the Supreme Court, which was basically this test of proportionality, right? So is the state action proportionate to the goal? And they did a step-by-step analysis and said, look, this is disproportionate, because protesters in assemblies and in protests have a well-founded fear of state persecution. They may need to, for perfectly valid reasons, hide their faces, and you can't, and your argument as the state can't be that some people are doing violence and therefore we will basically restrict everyone's liberties. Right? So the exact argument made in the Supreme Court of India. And we cited, the Hong Kong case, and the subtext of it was, and I can say it now, 4 years and 4 years after the fact, because it's been a long time, was that if a court literally under the pressure of the Chinese state is able to do this, what excuse do you have as the Indian Supreme Court to not do this in a democracy? Yeah, I mean, literally, like you have a court that is under much more pressure than that you will ever be. And of course, I mean, the Supreme Court gave us this non-judgment judgment eventually, which I think again this shows you just how far behind we are as a court, where Hong Kong in the midst of protests that as a matter of fact at various points had resulted in certain kinds of violent actions, was nonetheless able to draw these very basic distinctions in law, but we were unable to, in our court. So that's Hong Kong. You find similar things, in like East African courts. The Kenyan court being a good example of a court that is actually very speech protective and is, civil rights protective. There's another history over there, which is that they, for 20 years, struggled against a one-party state and were able to democratically restore, their multi-party democracy. And so there's a very keen sense there of how easy it is to lose these civil liberties, and therefore the courts are very, very vigilant about, not to allow a kind of slippage that would lead to, ultimately lead you to all kinds of restrictions. South Africa is another example of a jurisdiction where you have strong, speech provisions. Of course, the US is in a certain sense the most libertarian on these issues. So, and they have their own history of that. They weren't libertarian until the mid 1950s or 60s, actually. So for a long time, they were fully on board with banning communist parties, imprisoning communists and justifying that in court. It's only post 1960s that they switched to this position, which was that you can only restrict speech when there is incitement to imminent violence. In defamation, you can only restrict speech unless it is intentionally false or recklessly misleading, and other domains. So that's a recent development. And in the US also, of course, you have restrictions on speech. So it's a common misnomer that there are no restrictions on free speech there. You do have restrictions. You have restrictions on insider trading, which is of course an form of expression. You have restrictions on commercial speech. You have obscenity laws of their own. So there are restrictions there, and in certain ways, their position is problematic. So you can't have campaign funding restrictions there, right? Because of So there's I think the US is an outlier. But I think in other countries, I think better comparisons are countries like Hong Kong, countries like South Africa, Kenya, and so on, which have similar legal provisions, similar histories, where courts have been able to attain more autonomy from this logic of state when it comes to free speech cases.
have many follow-up questions, but I want to open up to the audience in the room and on Zoom. We already have a couple of questions on Zoom, but someone in the room wants to go first. You can take those questions. Yeah, Soumya. Do you have a mic? It's just right.
Hi, thank you for that really amazing talk. You'd mentioned about how theater was like a big part of revolting against, or like even during the pre-colonial times, and to spread awareness among people, etc. And there was legislation that was passed thereafter to kind of curb that freedom. Could you talk a little bit about that, and how did artists work around that and find ways to express,
Yeah, so there was a law called the Dramatic Performances Act, I think 1872, if I remember correctly, which basically brought in this regime of pre-censorship. So to submit plays in advance and so on. And of course, provided the government with wide-ranging powers to restrict that. That law is still, I think, on the books. It's not used very often, of course, now, but it's still there as far as I know, at a state level, I think. And of course, artists worked around that by basically framing what they were doing as purely cultural. So by saying that, look, we want to revive, Indian, or in this case, oftentimes Hindu culture. So you take all these cultural themes, but of course, in that cultural themes, you have lessons or morals about resisting oppressors, resisting tyranny, and so on. So I think Bankim was one of the famous people who began by writing these plays, which were ostensibly about restoring this lost civilizational grandeur, but then had these messages about resisting oppression. And of course, the British were not like stupid; they got it. So they would then ban those plays, and it was again this constant back and forth which happens in any situation of this kind, where you try and use indirect methods, allusions, double meaning, to communicate the message to the audiences who can get it, and then the authorities try and sort of figure it out and then go after you. That was how it happened over 20 or 30 years. William Mazzarella and Rupinder Kaur, I'll check the exact one. They have written 2 or 3 books on this. So on how the moving image or cinema, as well as theatre, how they became sites for this battle between cultural nationalists and the British for 30, 40 years. Laws and all that happened. So they discuss it in some detail with examples. Which plays were getting banned, which were being performed, and so on. Yeah.
Okay, so any other questions in the room? Otherwise, I'll take some questions from Zoom.
Thank you for coming. And you mentioned the logic of the state. As an outsider, I don't understand that. How come the higher judiciary ended up buying that?
So this is again, this is a long story, and of course there are many debates over it. I think there are a few pointers there. One interesting thing is that the Indian judiciary was completely unaltered, at independence. So the same judges who were basically the colonial federal court judges became Indian Supreme Court judges, which is very different from other countries. So in South Africa, for example, when they transitioned to a republic, the Constitutional Court was completely new. In fact, the Constitutional Court actually was made up of anti-apartheid activists, lawyers and judges. Not judges, because you couldn't really be an anti-apartheid judge in the apartheid regime, but it was really made up of anti-apartheid lawyers who had sacrificed a lot during apartheid to contest it. Same with Kenya. They had a complete overhaul of the judiciary, and then they had a completely new judiciary and so on. Whereas here you had the colonial officials who then became judges. So then there's one, I think, something to think about there. In fact, I was interestingly, when I was researching for this book many years ago, the judge who gave all these judgments in the 50s was a man called Justice Das. And if you look at his history, he was in Indian civil services. Actually, he was in the ICS. He wasn't even like a judge. He was in the ICS. So literally, he was basically enforcing colonial rule in like a district. How much more like they have to get, right, to be doing that? And he is now Supreme Court judge deciding on free speech cases. So again, I think there's there's something to be thought about over there. Of course, it's not about individuals finding it. It's about an institutional logic. And I think that there are two or three things. I think one is that there was, like I said, a very clear idea of nation building at that time. And part of that idea was, and if you go back again to the independence era, there was the sense that the people, of course, played a big role in independence, but there was always a risk of them spilling out over the boundaries set for them by the leaders, and the need to contain that possibility of a spillover. And there's this new book by Sandipto Dasgupta called Legalizing the Revolution, where he talks about that in a lot of detail. And so that idea that this new nation requires the people to have rights, but also to be disciplined in how they exercise those rights, was, of course, a major, plank of the immediate post-independence, ruling logic. And the courts see themselves as partners in that. So they see themselves as being part of that nation-building project, where okay, your job as the court is to check abuse by the state. Yes, so when the state goes beyond its remit, then you intervene. But if the state is trying to carry on with nation building by ensuring that you channel rights in a disciplined way, then the court will support that. That, to me, seems to be how I read these cases, along with other cases, for example, in Article 22, Gopalan, detention without trial, criminal procedural rights, self-incrimination, double jeopardy, and so on. So you see this happening across the domain of rights, where the court is like, okay, where we see what seems to be abuse, we will step in, but where we see the state trying to basically maintain order, we will defer to their expertise on that.
Just a supplementary, if you it's on compared to 50s and 60s or even 70s, the Supreme Court is much more statist now. What explains that?
I'm not so sure that there's a big change. I think it was statist from the beginning. And I think you see this, the only domain that wasn't statist so much was land reform, in the early years, where it sort of went up against the parliament many times. I think on civil liberties, there's been a much more consistent statist trend across the board. You have periods of thought, but the dominant logic, or what I call a constitutional common sense, so to say, it has always been a statist common sense.
If I can add to that, because I work on the property rights
Yeah,
cases,
yeah, yeah.
I would say that actually, and my work is sort of challenging that
Yeah,
conventional understanding. I think it has been stated in all kinds of cases to a greater extent than it should have.
I can inject a little more pessimism into that. Some kind
Please
of
use the mic as you inject.
third coalition. What is this? When the coalition governments are in power, it is much more assertive and for the individual rights.
No, so again, I think like that's a common belief. But if you look at the judgments upholding AFSPA, TADA, and POTA, they were all in coalition era. So I think there's a logic of the Supreme Court that is the Supreme Court is more interventionist in certain areas when you have coalition governments. But there is a core logic that is there, regardless of the government.
Any further questions in the room? Yeah, please. Do you need a mic?
Very interesting. I'm Simon Schäfer from the Swiss Embassy. And of course, a topic which is of interest also to the global debate, I believe, because it's always an evolving topic. I would be interested regarding when we look at social media, because the talk says also up to the present day. So that's why it's not only sort of from the since freedom or colonial, but also sort of the present day. I would be interested in your view how that debate sort of now transitions into the social media realm, where on the one side you have also globally some voices that say we need to moderate what is happening there, because virality can happen and it can make sort of fake news can become viral very quickly. On the other side, others will say moderation just means censorship, and who censors, who polices the police. So sort of, and what do you see is here how do you see it going, the discourse of the debate here?
Yeah, no, it's interesting that you asked that question, because we just finished doing this case. In fact, it got done today, which is about this fact check unit that the government wanted to bring in, and so they amended the IT rules to say that it is prohibited to host or cause to be hosted information that is fake, false, or misleading, as certified by a fact check unit of the government relating to business of the government. So, I mean, to break that down, it means that if this government nominated fact check unit, which is basically the PIB, designates certain information online about which is as being fake, false, or misleading, then there is an obligation on the intermediary, which is Twitter or Facebook or whatever, to take it down. And if it doesn't take it down, then it will lose safe harbor. But that's in a sense the consequence which was there. So all the issues you raised about virality and so on were argued in that case, and we are now waiting for a judgment on that. To take, I think, a few weeks. It was first argued before a two-judge bench of the Bombay High Court, and it was a split judgment. So one judge said that obviously, the state cannot decide what is fake, false, or misleading about itself. So that can't happen. So he struck down the rule. The other judge said that, again, given the spread of fake news and so on, this is something that's needed. It's now gone to a third judge to break the tie, and then it'll go to the Supreme Court, whatever the result. So all the issues you brought up were debated there. And I think ultimately the issue really is that to what extent does the admittedly, and this both sides in the case admitted, it need to ensure that the damaging effects of false news are regulated. At what point does that spill over into what is basically state control, or the state deciding what is fake or false? And how do you craft a law that accounts for the former but not the latter, was the challenge effectively. So that was what the case was about. So our argument was that we're not saying that fake news online is not a problem. It is a problem, but there are ways to tackle it that don't require this kind of coercive mechanism. So, for example, up till now, the Press Information Bureau, the PIB, it has its own Twitter handle, and it frequently debunks information there. So we said, look, if you have your own Twitter handle and you as the government have the biggest mouthpiece, why do you need a coercive method, where you say, okay, it's my truth, or you lose safe harbor? You can just literally correct, information you think false on your own handle. So yeah, there were arguments of that kind. So I think that it's obviously a complex issue. I think the key challenge is that how do you sort of ensure that there is regulation, but not state-imposed, restrictions.
Thank you.
So there are a lot of questions on Zoom. So one that is just related to what you've answered. I'm going to ask it in case you want to add more. What are your thoughts on deliberate misinformation affecting the public's mindset and how it can be countered? How does the free speech protocol address this issue?
Yeah, so I mean, it's the same answer, right? So obviously there is a problem, and when you have, for example, misinformation such as the election day has been moved, right? Which obviously it has not. Or you have information like, the polling stations have been closed, so don't go and vote because they've been closed. So obviously, that has a direct impact on democracy. But then you have stuff like, has India's GDP risen or not, right? And if there you then say, okay, look, you have said that Indian GDP has risen by 4%. By our calculation, is 6%. Take down this news, or we'll prosecute you. That's obviously where the problem is, and that's where you enter into the realm of state censorship. So the example I gave is actually in this case, when I was arguing, was actually a true example from South Africa, which I think shows you the difficulty here. Where in South Africa, when Zuma was president, he was, of course, a megalomaniac. So he basically, in his presidential palace, he built a kraal for his, animals, and he had a swimming pool, all that, and he used public money to basically do that. Now, when the elections are coming, the DA, which is the main opposition party, sends this bulk SMS, to voters, saying that the public protector, which is their CAG, their report has shown that Zuma stole your money to build his house. Vote DA. And Zuma says that, look, I have never committed theft. stole means you're accusing me of theft. There is no allegation of theft against me. So, you are basically spreading false information, right? And the whole debate, this went through three courts, High Court, Court of Appeal, Supreme Constitutional Court, was that when I say in a political context that Zuma stole your money, am I saying he committed theft, or am I saying that he has unethically used public funds in a way he shouldn't have? Because what does the word steal mean, right? So the debate actually was not just about is it true or false, but is it something that is even capable of being a true or false statement, right? And when you have this level of blurriness, especially in the political domain, like giving the state the power to control then would lead to all kinds of, I think, situations where ultimately they will use the power to get rid of opposing views. So your intentions will be good. We need to deal with stuff like election has been postponed, so don't vote. Whereas, what you will get will be this kind of restriction.
As they say, the road to hell is paved with intentions. The next question is the freedom of press not a part of freedom of speech? And how does this impact the freedom to post on social media and fake news, blasphemy, etc., which is related, but freedom of press is a subset?
Yeah, so I mean that makes no difference, because it's long been held that freedom of press is a part of the right. I mean, what the court has said is that the press cannot claim any special privileges, which again is kind of meaningless, because to the extent that one of the justifications for free speech is democratic debate, and to the extent that the press is engaged in disseminating those that part of speech, obviously it has a claim for protection. So I think that doesn't make any difference in at least the scope of the constitutional protection. What would make a difference would be, so for example, certain Latin American constitutions specifically bar prior restraint upon the press, right? So you cannot require the press to pre-censor. Now that would make an actual difference, but just saying that the press isn't part of 19(1)(a) is not really going to make a difference either way to the scope of the protection that it has.
Another question is that the censorship and attacks on free speech recently are coming from non-state actors, the hecklers, the mob, etc. And instead of upholding the artist, writer, speaker, blogger, would often side with the one who is offended.
Yeah.
There are the odd cases, such as the one involving Hansa, Sovendra, Shekhar, or but most of the times the court either grants the state the latitude it wants by not enforcing the rights of the speaker. Is there a way out of the conundrum, or do we have to wait for an odd judge who might issue a judgment that burnishes freedoms, but otherwise it is a one-way street? Yeah, I mean, in fact, the Perumal Murugan case is interesting because it's thought of as this great speech protecting judgment. If you read it, and it's long, so you won't blame anyone for not some 240 pages. Madras High Court from a few years ago. Probably summarized. Actually, it might be on the blog. It's somewhere. But the interesting thing is, and I think this is a problem again, which is sort of under discussed. Ultimately, the impression the judgment gives is that we are protecting Perumal Murugan not because of his right to speak, but because he's a good writer. So he's written like good books, and so suppressing him would be a loss to the literary corpus. Which is, of course, not the point, right? He could be a terrible writer. The point is that you don't ban books. That's as simple as that. And in fact, if you go back to Udeshi, the obscenity case, again, basically, and this is actually, you can read this case. It's short, 20 pages. It's so bizarre because what the court gets into is basically the quality of the book, right? So it's all about, like, Lawrence's treatment of sex is like bad, it's prosaic, it's not literally done, so they're not really about, is there a right, to speech? It's about that, is this book a good book, and should it be there? If it's not a good book, then it's okay to ban it. So I think that logic has been again there, throughout, the court's jurisprudence. In part, it's because of the test itself, because the classic test of obscenity, the exception is for works of literary value, which of course then gives the court this sort of foothold into getting into judging books for their value. But again, you see this problem across the domain of free speech. So this famous contempt of court case where Nambudripad, the famous Nambudripad, had said that judges are the agents of the class oppression, basically capitalist class, and he was hauled up for contempt. And he said Marx has said this, and I'm just following what Marx has said, and that's perfectly fine. And instead of getting in, assessing that argument,
the court actually says, well, Marx never said this, and you as Namudripad Marxists have misread Marx, and we will tell you what Marx said, and because you have misread Marx, you're in contempt of court, right? So this has been a problem with them throughout. I think that this is an institutional problem that will take some time to overturn. It won't happen anytime soon.
So there are two related questions. Do you agree that hate speech is not free speech? How to deal with hate speech while protecting free speech? How does the Supreme Court see this issue? And related to this, there are two types of speech if you have to categorize. One is extreme speech, which I think is what the person means is hate speech, and the other is disagreement. What, in your opinion, should be the distinction between these two?
Yeah, so this hate speech debate has been, of course, is a very old debate, and there are three broad approaches dealing with it. One is the US approach, which is that we do not regulate hate speech unless it's aggravated form of a certain kind of already prohibited speech. So like cross burning and stuff, that can be regulated. The second is the equation of hate and offensive speech, right? So hate speech is that which offends, and we will regulate speech that is offensive. You see that in many Indian cases, of course, and you see it in some ECHR cases where it's religious figures that are being targeted. So blasphemous speech about Christ, that Jesus Christ, and so on. And then there is the sort of the more constitutional principles route, which you see in Canada, in South Africa, in other countries, which is that that you to understand hate speech as being part of a web of actions whose effect it is to delegitimize the equal standing of certain groups in society, right? So anti-Semitic speech, right? So this the issue is not that you are insulting Jewish people. The issue is that whole hooked nose, like obsession with money and all of that is feeding into a broader climate of prejudice that then causes violence. That is what the issue is, right? So and similarly, to whichever community is being the target of that kind of speech. So, for example, again, this is a few years ago, so I can talk about it. Sudarshan TV at one point had this UPSC Jihad series, where what they did was that they said that these Muslims are basically taking UPSC lessons, and they want to enter the UPSC and then do jihad using that. Yeah, it was. Yeah, UPSC basically there are coaching centers that are taking lessons to study for UPSC, pass the exam, come into the UPSC, and then undermine the Indian state. And what they did was, so they said that, and they had this thing where, so I don't know if you've watched Russian TV at any point, but you had this thing where the anchor is talking, and on the side you have this sort of figure dressed in green with like a long beard, and sort of this sort of skull cap, and the building is blowing up, right? And this is like a non-stop. It's there throughout the whole 1 hour program. This is there, right there. Suddenly a building will blow up, right? And then this guy is like, there with this beard and skull cap. And so of course we said that, look, this is hate speech, and this is your classic dog whistle, right? So you can say, okay, this is just a figure, right? But your audience knows, what this is meant to convey, and of course you should stop that. Now, so to answer the question, I think so. Obviously, as a matter of principle, the court injuncted it after 4 episodes. So it stopped the rest of the series, but it took no action against Russian TV, and so they kept doing their stuff in other respects, right? So if you watch them on an average day, they do stuff like this much worse. So yeah, I mean, the court basically said, okay, it stayed that program, but then it never went back to the case, and yeah. So our whole point was that you have to understand this as a dog whistle, right? So this is not. If you look at it specifically as if you won't find the actual incitement there, but it is much more subtle, and that in turn I think creates the problem, which is that as a matter of, to answer the question, as a matter of principle, obviously one agrees that this is beyond the boundaries of what should be acceptable speech in a constitutional democracy, because speech is not just words. Like speech is part of what the English philosophers used to call elocutionary and perlocutionary speech, right? So speech has an effect, right? So you can do things with words, as the famous book J.L. Austin, right? So that's why that's the ground for regulating it. But the problem is, because it's so subtle and so insidious, there is a big risk in then saying, okay, you, the court, have to regulate this, right? Because the problem then will be that your judges come from, the society. They're not standing apart from it, right? And so what will often happen then is that it'll become, the application of the standard will not be objective, right? So for them as well, certain kinds of speech will be more threatening than other kinds of speech, and that will reflect upon where they come from. So I think it's a difficult topic, a difficult issue, because the principle is that this speech should not be there. But then when you move into, okay, how do you control it? You have all kinds of fresh issues that come up, and I'm not sure what the answer is, honestly.
That critique of
Yeah. Yeah.
backgrounds, doesn't that apply to everything? So even like when I talk
Yeah.
about property rights
Yeah, yeah.
cases, and
Yeah,
you're
yeah.
talking about, calling the
Yeah.
president's abuse of
Yeah.
power theft
Yeah.
versus,
Yeah.
the famous, property is
Yeah.
theft.
Yeah.
Is one approach towards
Yeah,
it, and
yeah.
there are other approaches towards
Yeah, yeah,
property
yeah,
rights where
yeah.
actually, the sort of liberal approach
Yeah.
was where, the rights to liberty, property
Yeah.
are totally and inextricably connected, and now
Yeah.
also to the
Yeah, yeah.
to the concept of human dignity.
Yeah. Yeah.
So I think that critique applies to
No, so
courts
yeah,
across the board.
completely. So that critique is there in any sphere of education. In the speech context, there are two arguments basically. One is that, okay, you give judges this power, and then what will happen will happen. Yeah, the other argument, which I had much less patience for earlier, but I have more patience for it now, having seen how judges actually decide cases, is that ultimately there should not be, even hate speech should be allowed, because ultimately you will get hate speech in that context, but you will have actually more censorship of valid speech if you give judges the power to decide what hate speech is, and so ultimately you will have a much worse outcome if judges have the power, because you think, okay, they will they will get anti-Semitic speech, right? They will get Islamophobic speech. That's what they will go after. What they will go after will be, say, communist speech, saying that abolish property, and you don't want that, right? So I think there are these two arguments. One is that give them the power, take the hit. The other argument is that ultimately it's better that they don't have the power, even though we accept in principle that certain speech should be beyond the pale. And I said I'm unsure about which of them is correct now. I was much more certain earlier, but reality then teaches you some lessons. Then much
Are there any other questions in the room? There are many still on Zoom, but if we can turn back to the room. Yeah, Ruby? Do you need the mic?
You alluded to it briefly, but when we're talking about criminal contempt or contempt of court, what sort of debates around free speech arise from there? When it's not about public order or moral order, but order of the court.
Yeah, the main argument is that judges can't talk back, right? So judges cannot. So if you criticize a judgment, judges cannot answer you. They can only speak to the judgments. They can't respond in the public domain. So if I call a judge corrupt, or if I call a judge, acting on state's instructions, right? They can't defend themselves and say, look, I'm not corrupt, or I'm not acting on instructions. So therefore, the classic position is that while you can criticize judgments, what you can't do is that you can't, without proof and without active proof, you can't say that judges are, or no, a specific judge is sold out, corrupt, dishonest, or something of that kind. Of course, you can, again, in theory, you can make critiques of the judiciary as an institution. That okay, like it's again, like expression of class interest and so on. You can say that. You can't say X judge took money to deliver Y judgment. That's sort of what you can't say. Of course, in practice, then it becomes all blurred, right? So, and of course, judges then try to expand the scope of contempt. Yeah, I mean, there's an interesting recent case where, again, from Kenya, where there's a senior lawyer, and he would keep tweeting saying that Chief Justice has taken, is done this, has done that, and it's the judiciary's taken money and so on. And people say, okay, like, either you prove it, or there is actually a method to impeach a judge, right? In Kenya, you go through the Judicial Services Commission. So take that route and show your proof. He never did that. So finally, what the Supreme Court did, and this is interesting, they didn't actually summon him for contempt. They said that henceforth we will recuse ourselves from all cases in which he appears as the counsel, because he doesn't have faith in us. So why should he then appear before us, right? So they then said, okay, henceforth, effectively they banned him from appearing from them, and there's a big controversy began. Can they do it? And now the High Court is hearing a challenge to that. So it's actually a lot of fun, But yeah, so to answer the question, that is effectively what the argument is, that because judges can't answer you, therefore there are certain kind of things you can't say, but other than that you can. In practice, of course, it's much more messy and blurry.
Could you say that
Yeah.
classical approach
Yeah.
still apply now that we have recording of court proceedings? We have Justice Chandrachud speaking on India Today platform about the court.
Yeah, I mean,
as a
so
sitting judge.
it's actually obviously, I mean, so what the present Chief Justice is doing is a little unconventional in the sense that sitting judges are normally not meant to defend their judgments in public, right? Of course, they can give interviews about the judiciary and administration and so on. It is a little unconventional to go on TV and say, look, this is why we decided the same-sex marriage case like this. Right? And that does, of course, take away from some of the logic of the rule. But I think that there is still good reason why we have that rule, because there is a problem if you start publicly saying X judge is bribed, right, and you don't have proof for it. You can't really go on like that sustainably in a system where judges are given this power. You can have a debate over should judges have this power that they do in our system. If you've given it to them, I think then certain kinds of attacks, you have to say, okay, these are off limits given that this is our system. I think that there is still some sense in that classic rule.
Next one.
Sorry, just before that, just on contempt. Is that question on contempt? Yeah.
No.
Okay, just one follow-up,
Yeah.
because I wrote on my law school papers on truth as a defense.
Right.
Could you speak to that as well?
Yeah, so now there's a Contempt of Courts Act, which says truth plus public interest, right? So it has to be true and in the public interest. But again, I mean, the thing is, in most of these cases, you wouldn't be able to prove it. So if you say X judge took money from Y for deciding, delivering this judgment, if you had proof of it, then you.
Shouldn't truth be enough?
Ideally it should. Yeah, but in India, both in criminal defamation and in contempt of court, we've added this requirement of public interest, which shouldn't be there, but it's there. Yeah.
Please, go ahead.
So my question is taken into account. Can you visualize a situation or a social or political condition in which the free speech exists or practiced as a free speech without any
As a?
inhibitions? Free speech in any social conditions or in any political condition is exercised or practiced as a free speech per se, without any inhibition, without any restrictions.
No, that's fundamentally impossible, because you will always have, for example, consumer protection laws, or you'll have laws that prohibit mislabeling of goods. Just as a very basic example, you have every country has laws on consumer insider trading in the stock market, right? So there are all kinds of speech that you have to restrict. So I think there is no such thing as a jurisdiction where speech is absolute. The debate's always what kind of regulation do you have and who regulates. That's always the debate. It's never that can we have a situation where speech is absolutely free and where it's not.
I have a question actually. So the recent the broadcasting bill that has come out, the draft.
Yeah.
I
okay.
have the
Yeah.
mic.
We'll
So-
bring it closer.
Okay. So do you think the draft or the bill that might come up is kind of a violation of freedom of speech for citizens and journalists who have moved to YouTube now?
Yeah, it's very clearly a lot of overreach in that bill, and it's in my view definitely contrary to the Constitution. Whether the court will agree with that or not is something that we will have to see in due course.
So the next question on Zoom is, could you discuss the historical background of IPC section 295A and its relationship with the Pakistani Penal Code sections 295A, B, C?
Yeah.
Is there any move to challenge IPC 295A in terms of restrictions it places on the criticism of religion?
So there is, I'm a little hazy on the history now. It's been a while. Neeti Nair has this great book on it, which I would recommend, and a great paper also on it. Hart is the book, and then there was a paper she wrote, which was the whole history. My memory is that there was this book called Rangila Rasool, which was published and then there was obviously, as the name suggests, it was attack on the Prophet, and then the I think the publisher or the writer, one of them got stabbed, and then in turn someone published counter text about Hinduism. I've forgotten what it was, and then there was violence, and so basically to sort of ostensibly to curtail that, they brought in this law. And then in the colonial assembly, there was strong criticism. Jinnah did not like it. For example, there were attempts to have exceptions attached to it, like reformatory exceptions, which finally didn't go through. And then you had what you finally had. That's my sketchy memory of the history. But like I said, for the more detailed version, Niti Nayar's article and book, are the authoritative sources. Challenge to it is not on the horizon, because as I said, in Ramji Lal Modi's case in 57, that's when the Supreme Court upheld it. Right? So you actually have a 5-judge bench upholding it on public order grounds. And I think, given the present climate, I strongly doubt any attempt to strike it down will be successful, because you have far too much jurisprudence now on this whole thing of hurt sentiments and protecting them. It'll be next to impossible unless you have a fundamental and seismic change in just the constitutional common sense in the court, and that takes a long time to accomplish.
Could you pass the mic?
During this anti-CA protests, we had this minister who was openly saying, "Desh ke gaddaron ko goli maro salon ko," and nothing happened to him. And on the other hand, this Umar Khalid, he's in jail, and he didn't get bail also, because he said Pradhan Mantri jumla baji karte hain, and the words used for greeting this audience, istikbal, krantikari istikbal. How do you reconcile these? Judiciary is comfortable with both the things.
Yeah, so so I think that there are 2 or 3 things here. One is that in the case of the minister, there are 2 things. One is that you have to prosecute a minister, to have sanction for prosecution, which the government gives. So which is obviously they will not give. And again, in his case, his defense was basically this dog whistling defense, right? That I only said that those who are traitors, should be shot. What else do you do with traitors? So you had this defense that he gave, and I think there was an attempt to go to court to register an FIR against him by a judicial sanction. But I don't really think it's like no court is going to in that way take on a sitting minister. It's just the balance of power that is just not going to happen. It's just when realpolitik takes over, any principles that there might be. The Umar Khalid case, of course, is the egregious one, right? So and if you read the judgments, the High Court judgment, and it's in a much darker way, this reflects what I was saying about the court, deciding it's a judge of literary sentiments. So there, the High Court says that actually, why did he say revolution? He should have said peaceful revolution, to clarify that he was talking about a peaceful revolution. If he didn't, that he did not say peaceful revolution, we must assume that he's referring to a violent revolution. And then the court quotes, I've forgotten who the court quoted. Quoted a bunch of writers, right? So it was completely senseless, and this is something that is to anyone who's familiar with political idiom, in India, knows that revolution is one of the most the cheapest of political currencies, right? Everyone says revolution. Remember Arvind Kejriwal, when he started Aam Aadmi Party, his whole thing was the revolution is coming, and if you read the assembly debates, everyone is saying, that the revolution, we now have a revolution. Nehru is one of the foremost propagators of the idea that, we will have a revolution that will change everything. So yeah, I mean, that judgment is completely indefensible, and its logic is it doesn't stand up to scrutiny at all. Why the court did that, is something that I think people know about, and it's very clear, what's happening over there.
So our next question on Zoom is that the questioner agrees with your critique of the Supreme Court and the judiciary as enabling the restrictions imposed by the state on free speech, but would you agree that the ambit responsibility needs to be cast much wider? For instance, Reference points that may be pertinent would include the ways in which political rights for minorities got contested and settled through the inter-World War years. I was looking at the Motilal Nehru report of 1928, often referred to as the first draft of the Indian Constitution. It is so striking how acceptance of the linguistic provinces as the federal principle in the Nehru report is premised on a vitriolic delegitimization of separate electorates and the insistence of the need for joint electorates. Against this context and debate, the Nehru report accepts the demand for Sindh as a separate linguistic province by the Muslim majority. This is a very early concession to majoritarianism in the name of democracy. Would not such comprising arguments at a foundational structure impinge on the space for civil liberties?
I'm not entirely sure of how strong that connection might be, because, like I said, the Congress itself, until independence, was committed to extensive, free speech. I mean, they had their, Civil Liberties Union, all of that, and Motilal Nehru himself had a report like before that went into some detail on executive suppression of speech. So I don't know to what extent that logic overlaps neatly. I think there is an overlap in the sense that that at the time of independence, right, there is this broad idea that has to do with a kind of national unity, right? That the framers have, and that things that threaten that sense of unity, are to be dealt with, right? So whether it is separate electorates, which they out of hand dismiss, whether it is other kinds of safeguards, political safeguards for Dalits, which they dismiss, they limit it to a certain limited set, because they look at it as affecting the possible unity of the nation, whether it is the strong centralizing parts of the constitution, and whether it is the denial of autonomy to 6 schedule areas, where again the debate entirely is they will become tribal stands and so on. You have this common thread of the fact that the constitution is not recognizing a pre-existing national unity, but has to create one, right? And that requires the active suppression of certain kinds of conflict. And of course, where speech becomes part of that, you suppress speech. So I think it's more, perhaps the overlap is more there than it is further back in time, is my view.
The next question is, how is it that the Dravidian ideologues' overt hate speech against Brahmins, including overt threats and incitement to violence over decades, continue to evade the notice of the
Well, actually, the 16th Amendment and UAPA was brought about specifically, because of the Dravidians. So in fact, the UAPA that exists now is the latest version of the UAPA of 1964, I think, or 65, which in turn was brought about after the 16th Amendment of the Constitution, which brought in integrity of the nation into 1902. So actually, the Dravidian speech is responsible for the UAPA. So I think you so if you're happy with the UAPA, you can blame them for that. On the time, I'm kidding, obviously. Yeah.
And the next question is about Judith Butler. She talks about a bad subject where she gives the notion of power as something that produces resistance by not reacting to the hate speech. Do you think this version of interpellation reduces the impact of hate speech?
I haven't read this, so I'm not in a position to answer it. I'll read it and get back to whoever to ask the question.
And there's one more question which I'm going to ask since it's been posed. How does India's land governance compare to its neighbors in countries with similar socioeconomic profiles?
Land governance?
Yes. I'm not sure.
In the sense of like
land governance. So I think that might not be a question
my question for you.
me,
Yeah.
Yes. But I think that this is a question that perhaps deserves time other than in this session, but hopefully
different seminar.
Yeah, different seminar. But we will. I have made a note of this question, and hopefully in the series we can talk about this when we talk about legal history of land rights. So those are all of the questions on Zoom. And are there any further questions in the room? Yes, please.
Hi. My question is pertaining to sedition. So in 2022, there was a stay on any FIRs on sedition, and then in September last year, it was sent to a larger bench. So does that stay, like, does it continue?
Yeah.
Still?
Yeah.
And
But not on the new provision. Stay on the old
Yeah.
provision.
so how does the larger bench judgment would affect the newer provisions?
To
Will it
the
affect-
extent that it would lay down certain principles of free speech, and to the extent that the wording of the new one reflects the logic of the old one, you would have to then have a fresh challenge and say that the judgment has an impact on this one. It wouldn't directly apply. So a judgment on the old tradition provision will not mean the new one is unconstitutional, but it would give a powerful argument against it.
Yes, please.
So, with respect to freedom of speech, the judges have been flexibly asserted, and which actually gives room to the uncertainty and unpredictability of cases. So, don't you think this actually weaken the rule of law in as a whole? I mean,
Yeah, judicial discretion actually is inevitable in these kinds of cases. In fact, I think that they have been very predictable. They've been predictable against, expanded free speech. In that sense, I think people are put on clear notice that, look, if you have speech that is critical of religion, any religion, or is of certain kind, and your book gets banned, or you get prosecuted, the courts will in all likelihood not protect you. And I think any lawyer who's basically worked on doing the legal read of a book draft is well aware that of that. So I think in that sense there is consistency. It's just a bad consistency, not a good one. I think that there is definitely consistency in how they approach the issues of free speech.
Yes.
So you talked about, that particular instance where Nehru himself had to read the book and everything. The point is that if the judges are very trained and they have many years of experience and they've got there and, so they have the ability to take such calls and so on. How does a politician come into the picture and why did he?
Oh, because a ban on books under the criminal code is a government ban. The government bans the book, and then you challenge it in court. So, under our legal scheme, the ban is by the government. So,
How did he get the power to?
no, the government has the power to ban books under the Indian legal scheme. Yeah. So I don't know the new provision. Under the old CRPC, Section 95 of the old CRPC, the government was empowered to ban books. Still is under the new provision. I've forgotten the exact number, but and then you can challenge that ban in court. But the initial power to ban is with the government, which is why Nehru was reading this book, and yeah.
Similar question. Mr. A.J. Nurani used to write a lot on this topic, which is how come state governments, like a chief minister, ask the police to file charges or file a criminal case or withdraw a criminal case? Where does a politician get that power from?
That's a different question. It's not really a free speech question. And, the answer is that Indian police are not structurally independent of the government. So there's no constitutional or legal provision that guarantees their independence from the political dispensation. So until that happens, until the separation happens, like in other countries where the DPP, is an office which is actually taking the calls on prosecutions without interference from the government, you wouldn't have that in India. Legally, that doesn't exist. You have a judgment called Prakash Singh, which the Supreme Court said that you should do this, but that's not followed by any of the states. So that separation between the police and the government is not there in the Indian legal frame.
So other than the judiciary is higher.
Higher in the sense of?
The judiciary can take calls on its own.
It can review governmental action for compliance with law and the Constitution. Yeah.
So we are on the hour. If there are no further questions, I have one last question for you. Any further questions? No. Okay. Can you sum up for us the current legal position and any current legal challenges on the 5 areas that really concern free speech
Yeah.
and what you've spoken about, and also what all the questions have
Yeah.
been about. So those 5 areas are
Yeah.
sedition, which you've
Yeah.
explained in response to the question
Yeah.
from this gentleman, that things have been stayed,
Yeah.
but it depends upon the BNS provision. And I also recommend that those of you who missed our previous talk may want to listen to it, where Sri Singh, who was talking about the new criminal codes, did talk a little bit about the new sedition provision. I mean, he's covering 1,000 provisions, so he spoke like 2 minutes on that. But for that, so sedition, yes, you answered, but what is the law of, and you've answered contempt of court, which is truth plus public interest is the only defense. But what is the current legal position on criminal defamation and on hate speech and the blasphemy
Right.
provision?
Yeah.
And could you also talk about any current legal challenges to that current legal provision?
Criminal defamation is still on the statute books. Supreme Court upheld it in 2016 in, I mean, a very shoddy judgment. It is what it is, but it's there. Yeah, so it exists and it's being used, as we know, in that Rahul Gandhi case was the striking example of that. As far as I know, there's no pending constitutional challenge to criminal defamation. But again, you never know. Someone may have filed a PIL and you're not aware of it, and it suddenly comes up one day. When was this filed? But yeah, so as far as I know, there is no pending constitutional challenge to criminal defamation. Blasphemy, I think, same thing. It was upheld in 1957. As far as I know, again, there might be some challenge somewhere there in the court's records, but nothing that is presently moving as such on that. You need a 7-judge bench to strike it down. So that's on blasphemy. Hate speech, yeah. So hate speech, you have these 2 or 3 judgments of the court that talk about hate speech in a very abstract, theoretical way. And there is this ongoing case that asks the court to take action on various hate speeches being done across the country, which is not being listed for a long time now. So I don't know what happens with that.
Judicial evasion.
That's judicial evasion. Yeah. Evasion.
Can you
Yeah.
explain that?
That's basically that the court avoids or evades hearing a case, and its evasion hearing a case benefits the executive or the state, because the status quo, is favors the state. So, for example, the Aadhaar challenge, the court spent 6 years not hearing it and not staying it. So basically, Aadhaar could become a fait accompli over 6 years before the court finally heard the case in any way, upheld it. But yeah, so in many politically sensitive cases, the court, instead of deciding the case, just avoids hearing it, which they can do because the docket is so massive, right? So they can just say, okay, look, we don't have time. But it is a strategic choice that then ensures that without a reasoned judgment, effectively it's still in favor of the state, because a non-judgment still benefits, the state, because the law presently is there, right? So I think, yeah, that's it. What was the other one? Hate speech. Yeah. I mean, then the other, of course, the main issues, the main pending cases are around the IT rules. The various restrictions on intermediaries. So one thing, so the Bombay High Court, finished today. In fact, argument finished today on that. And yeah, so intermediaries, fact check unit, compelling these grievance officers, blocking websites. So all of that is this ongoing daily battle in various courts.
Okay, so and related to that, what do you think in terms of going forward? So these are the current challenges. What do you think is the biggest worry for you in terms of restrictions to free speech that you can think of? And it could be from the state. You were mentioning Twitter, but one of the big criticisms of these agencies, like of these big corporate control. I mean, that is the state's argument, right? And it is to some extent, it is a very valid argument, the fact that when Elon Musk has taken it over and how Twitter is being used, and we are between 2 behemoths, the corporate power and state power. And when we were talking about US free speech, and you said the libertarian speech, in the US context, even though the free speech is way more free in many ways, there are questions about, for example, there has been no coverage in the mainstream US press about Gaza, precisely because of the lobbies that control corporate speech. So what do you think is the biggest challenge in your view? And I don't want to make it a binary, but in that sort of decision about where the regulation should happen, should we let the state regulate it, or should we leave it up to the big corporates? Where do you see that balance sort of coming?
I think like for me, the biggest issue has always been I mean, all the other issues are, I think, solvable in different ways. But the big issue is the unequal access to the infrastructure of speech, right? So, whether in the old days, and this is why many of the initial battles over free speech in India are about newsprint, right? So, newsprint and access to newsprint and so on. And then, in Express, Bennett Coleman, those cases. And now, of course, social media. But, unequal access to the infrastructure of speech, whether print or TV, online, of course, less barriers, but still they're there, which then allows certain people, whether it's a state or non-state, disproportionate power in shaping the environment in which we exist and live in, and which therefore shapes us. So I think for me that is the big problem. How do you solve it? If I had an answer there, then yeah. So I don't know what the answer is, but for me that's sort of the urgent issue. Just the unequal speaking power that certain people have by virtue of access to money or political power, which gives them this disproportionate influence over the public sphere, is for me the real problem.
And finally, the last question related to this is that even though, and maybe you can answer this, and maybe this requires further investigation. But for example, of the 5 areas, we've talked about, sedition, criminal contempt, criminal defamation, contempt of court, and hate speech. Sedition in some ways is the most draconian in terms of the criminal, the penalties involved. But I wanted to get a sense from you, which is the most used in order to suppress speech. And I also, I remember that about 5 years back when we had elections in Jharkhand, for example. So just before that, some 10,000 people had been slapped with sedition charges who were protesting against the changes to a colonial law. This law, which protected the land rights of tribal communities in Jharkhand. It's called the Chota Nagpur Tenancy Act. And again, that sort of brings to the fore this sort of, the fact that there is no binary as such between bad colonial laws and good post-colonial laws. But there are some colonial laws which actually are protective of rights. And when the democratically elected state wanted to actually change that law, people were out on the streets protesting, and 10,000 people were served with sedition charges. But when the government in Jharkhand changed, they actually drop those sedition charges, which is also what you were talking about. The sanction to prosecute comes from the state. So if the state decides to drop the charges are gone. But that again, which is the most used provision? Because sometimes the more draconian provision is less used, and therefore the less draconian provision may be more from a social and social perspective of sort of looking at how much impact it has.
I think that requires empirical research, because many of these cases will never come to court, right? So they'll be dropped at the charge stage, and they've done their job of suppressing speech. So I think it's really hard to say. Sedition is used very often. For online speech blocking, the blocking powers are used very, very often. That's what I know. But which is the most used? I think it requires empirical research to come to a conclusion.
Maybe that is something that all the younger researchers in this room can work on. But on that note, I think all of you will join me in thanking Gautam for a really wonderful, very, very informative and illuminating talk about the challenges before us as we speak and as we regulate free speech.
Thank you.
Thank you.
Please come again.